Hello and welcome to this Field Seymour Parks webinar. My name's Ian McRae and I head up the employment law team here. And what we're going to be doing today is telling you of all the key developments so that you're ready for 2018. This is part 3 of a 4-part series, and we're going to be giving you a very much whistle-stop tour of the general data protection regulations. Now, the first thing I should point out is that we do have a standalone webinar recorded on this issue by my colleague Jackie Denham. If you'd like the notes from that, then equally please let us know, and you can find that on YouTube or indeed on our website. What I'm going to be doing here is giving you a much briefer summary of some of the key points. So let's have a look at the general data protection regulations. So EU regulations due to come into effect on the 25th of May 2018. And in very basic terms, they place some restrictions and requirements on the processing of personal data. And both processing and personal data are given very wide meaning. So personal data can include anything from contact details, email addresses, things of that nature, through to much more sensitive stuff around employment records or indeed medical records. Processing, again, very wide meaning, can include just the storage of data, can include the analysing of it, and indeed the use of it in your business. Now, one of the key principles of the General Data Protection Regulations is this idea of transparency. And what that in reality means is giving certain information to the data subjects, to the people whose personal data you are holding or using. And in essence, you need to tell them the source of the data, so where have you got it from? You need to give them the identity of the body that is going to process it, so probably your business. You might need some contact details there. Who receives that data? Who do you pass it on to? And if you are going to transfer it overseas, there's some additional protections and information that needs to be provided. How long are you going to hold it for? Are you holding it for a statutory or contractual requirement? And if so, if they refuse for their personal data to be processed, what does that mean? It may mean that you can't perform the contract. You also have to declare any automated decision making, and you also need to give them specified information about their rights, and we'll have a look at that in a little bit more detail. Other key thing is this idea of having a lawful reason for holding and using the personal data that you have. So lawfulness, what does that mean? Well, for starters, you could have someone's consent to what you're doing. Now, consent is much more difficult to get under the General Data Protection Regulations than it was under the old Data Protection Act, and we'll have a look at that in a little bit more detail. Also, if it is necessary for performance of a contract or to comply with a legal obligation, that can be a lawful reason for holding or processing the data. If it's in the vital interests of the data subject or somebody else, again, another lawful reason. Tasks in the public interest, and then this final one of this, things that are basically in your legitimate interests. Now, that only works as a lawful reason if you balance it against the rights of the data subject. Additional restrictions on special categories of personal data, which is very similar to sensitive personal data under the Data Protection Act, so things maybe around someone's religion or ethnic background. Additional restrictions on how you use that information. And what I want to do is look a little bit more about the difficulties around consent. So for consent to be a valid lawful reason, there are various factors that have to be met. So it has to be freely given, and they have to be able to withdraw it just as easily as they gave it in the first place. It needs to be specific and unambiguous. So they know what they're giving their consent for. Also needs to be informed, so they need to know what they're doing and what their rights are. And it needs to be a clear affirmative act. So the days of sort of silence or pre-ticked boxes, that's not going to work anymore. The key point from this, particularly as we're talking about employment law, is consent doesn't really work in an employment relationship. And the reason being is that the guidance says that in an employment relationship, the employee is essentially always at a disadvantage. It's not an equal relationship. And so it's going to be very difficult to establish that you've got a freely given consent. So what that means for your employees is you need to have one of the other lawful reasons for processing their personal data. Other principles in brief, obviously if you've got a legitimate purpose that only works for that purpose, you shouldn't be using that data for something else. You should only keep what is necessary for as long as is necessary. You should ensure that the data you hold is accurate, and obviously you should keep it secure. Now, data subject rights. So these are certain rights that these sort of data subjects have in respect to their processing of personal data. So data subject access requests are still there in the GDPR. Slightly different, 1 month deadline rather than 40 days, one of the key changes. There are some new rights as well though. There's a right to rectification, which basically is where there's inaccurate or incomplete data. The data subject, the individual, could say that you've got to rectify that. If you've unlawfully processed someone's data, then they could have what's been called the right to be forgotten, essentially to remove their data from you. And you can have restricted processing or objections to processing if they don't think that you have balanced your legitimate interests against theirs. Data protection officers, if you're in a public body or you are systematically processing personal data, there may be a requirement on you to have a data protection officer, and that's something you need to consider. New obligations on reporting data breaches, and that can be as short as up to 72 hours to report those now to the Information Commissioner. And greatly enhanced sanctions for breach. The possibility of fines is greatly increased, and there's also some sanctions around inspection. So, very brief tour through the law behind the General Data Protection Regulations. What do you actually need to be doing now? What steps do you need to take now? The first thing I would say is you need to be doing an internal audit to see what personal data you hold. So you need to be asking questions about what you hold, where you hold it, who has access to it, why you hold it, how long you retain it for, and indeed where you send it, to what third parties, to any overseas territories. And until you understand exactly what is held and processed throughout your organisation, not just necessarily your employment records and HR, but your marketing information, your customer information, your supplier information, your referrers, your business contacts, you need to assess that across the entirety of your business. But until you've done that and you know what you've got, you don't know how compliant you are or what you might need to do. Once you've done that audit, you then need to make some decisions. Now, that could be a whole host of things. It could be that there are simply elements of personal data which you have no basis to be holding and should be deleted. But it could be other more specific things like limiting access to certain types of data, increased security, changing the retention periods you have for certain things. But the things that are likely to be required for most businesses, you are almost certainly going to need to update your data protection policy, and you're going to need some specific privacy notices. So when I looked at earlier on about this issue of transparency and the information you need to give to people, well, that information is going to be quite different depending upon the relationship you have with them. So the information that you hold about your employees and how long you hold that and why you hold that is going to be quite different from the information you might hold about your customers or your business contacts. So you're going to need a specific privacy notice for each sort of class of person. You need to check your consents because you've seen the requirements there and check whether the consents you have are valid. Review your third-party arrangements. You might be doing what you should be doing, but are the people you pass the data to. Reviewing and updating your contracts, and that could be employment contracts as well as your terms of business. Think about that need for a data protection officer, and then ultimately you've got to launch all of this and make sure people are complying with it. And there may be a training point there as well. So, a few final points. That is a very brief summary of the General Data Protection Regulations. Please do seek your own legal advice on your specific circumstances. If you want updates on employment law and indeed on how GDPR develops, then please just email me. They're offered as a free service. And equally, please do get in touch with any feedback, questions or suggestions for future topics. If you haven't already watched them, this is the third part of a 4-part series. And please do watch our elements on holiday pay, worker status and monitoring at work.